Mr. Speaker.
Chris Hipkins.
Mr. Speaker, and all of that noise from David Seymour in passionate defence of partnership schools or charter schools, he didn't really give a reason why they shouldn't be covered by the Ombudsman Act or the Official Information Act, except at the very end where he said, oh, then people might ask them for information. That seems to be his objection. On those grounds, I think every government department would like to see themselves exempted from the Official Information Act as well. But the reality is, if Mr. Seymour and the national government are so proud of what partnership schools are doing, why would they want them exempted from the Official Information Act? Why would they want them exempted from the Ombudsman's Act? And I just want to talk particularly about the Ombudsman Act for a moment, because there is a provision, and it was negotiated at Select Committee by Tracy Martin, Catherine Delahunty-I and others, to ensure that part of the Ombudsman Act would apply to partnership schools, but only part of it. And it was only insofar as it relates to disciplinary decisions, stand-downs and suspensions and so on. But then I want to consider the example that the Ombudsman gave us in his submission to the Select Committee, which went much wider than simply those decisions around stand-down and suspension. And that was of a school which I am very familiar with, where there were systemic bullying issues. The school failed the students involved, the Ministry of Education failed the students involved, and so did the Education Review Office. And ultimately, it was the Ombudsman that got to the bottom of that situation, ensure that it was brought to the light of day, and ensure that the problem was dealt with. These were very serious problems, including, I'm not going to go into all of the details, the violation of students with a broomstick. And all of the official agencies responsible for dealing with those problems failed those students. And the Ombudsman, the last safeguard, was the agency that finally dealt with it. If that was happening in a partnership school, there would be no final safeguard available for those students. So if the ACT Party and the National Party are so proud of partnership schools, so confident that they are supplying a higher quality education than every other school in the country, so confident that they are so much more accountable, why wouldn't they want them to be covered by the Ombudsman Act and by the Official Information Act? And they haven't actually answered it. All they've said is that they think it might be a bit much work. That seems to be the sum total of David Seymour's argument, that if somehow people were able to complain to the Ombudsman or ask for information under the Official Information Act, that they might actually do so. And wouldn't that be a terrible thing in the world of the National Party and in the world of the ACT Party? The Ombudsman came to the Select Committee when this bill was being debated and actually took the very unusual step of presenting before a Select Committee. The Ombudsman, as an officer of Parliament, does that very rarely. And in fact, it's happened twice, and to my knowledge, in the time that I've been an MP. Once was in this case, and the other is now in the case of schools, the online learning schools, which the government are also going to exempt from the Ombudsman Act and the Official Information Act. It's very unusual. And the Ombudsman basically had to come along to the Select Committee to defend their very existence. Because if parts of the apparatus of government, and schools are a part of the apparatus of government, are going to be exempted from the Ombudsman Act and the Official Information Act, then the Ombudsman is really coming along to justify their very existence. That's quite an unusual thing, and as I think the Ombudsman says, it is a constitutional anomaly. Because actually the Ombudsman Act and the Official Information Act are parts of our constitutional framework. They are vitally important. They're part of the process of open and transparent government. Now, I'm not going to get into an argument with David Seymour about the performance of partnership schools or otherwise. There are plenty of opportunities for us to do that, and we certainly do, and that is a very legitimate thing for any political parties to be doing. And I would encourage David Seymour not just to look with rose-tinted glasses at the performance of partnership schools, but actually have a realistic look at them and actually look at some of the pitfalls and some of the problems that have been encountered, because it hasn't been all sunshine and there have been some legitimate issues, and rather than turning a blind eye to those, perhaps he would like to deal with them. But no, he's not going to. But we'll debate those at another day, because actually the purpose of this bill is actually quite a narrow one. It's not actually an attack on partnership schools. It's actually saying that they should be simply accountable to the public, and that they should be subject to the same provisions and protections as state schools are when it comes to public transparency and accountability.
Members' time has expired.